This is Kelly with Broaddus Properties Group. We're doing a very special series. We'll probably be airing one of these videos per month, and this is a series on estate planning. We will be talking to Ashley DeBoard from the Flagstaff Law Group, and she's going to be answering a couple questions a week that are really important to estate planning. I hope that you'll join us and enjoy these very helpful and informative videos. She's available to book a 15-minute consultation for free for any of you that are interested, and you can just go to her website, which she talks about at the end. What about someone who created a will with an attorney 10 years ago and they die, and that will is found? What happened in that case? No estate planning, just a will is found.
Yeah, so it really kind of depends on the situation. There's a lot of factors that go into play to determine how that will all unfold. Generally, if the plan is outdated, if the assets have changed, they may not be in step with what the will specifies, so it can go in a different way than what the will directs. And certainly if all you have is a will and no other planning in place, then most likely those assets are going to have to go through probate court before they can get to the beneficiaries named in the will. That's often a common misconception that I see is folks think that a will is all you need. And while it's a really important tool, it's not by itself going to avoid probate court. It's simply going to direct the court who's in charge and how your assets get distributed at the end of the process.
What are the most common ways to hold title in real estate, and which way of owning real estate is the most protective?
Well, there are a number of ways that we can hold title to real estate. I would say probably the most common would be joint tenancy or community property with right of survivorship. Another way is tenancy in common. Or folks might be holding title to real estate in a revocable living trust, or possibly in an LLC or other type of business entity. So joint tenancy with right of survivorship or community property with right of survivorship is essentially going to avoid court at the death of the first joint owner by allowing property to pass to the surviving joint owner automatically. So it doesn't have to go through probate court to have that legal transfer occur. It's not probably the most protective if one joint owner becomes incapacitated before they die and sale of the real estate is needed, because without any other kind of planning in place, it's going to probably prevent the handling of that real estate asset without going to court. It's also not really ideal if something happens to both joint owners simultaneously. So if there's an accident and both joint owners are involved, it's not going to be foolproof in terms of avoiding probate court. Some folks come to me and they want to also add their adult children as joint owners on their real estate. So they'll just add an adult child as a third joint owner, thinking that they can kind of get around probate court by just having their child on the title. But this often will deprive the child of one of the biggest benefits that come from our death, which is a step up in basis for the capital gains tax. So if it's transferred to them after death, then they can receive it in a way where the cost basis goes up to the value of the property at the time of death, reducing the potential capital gains tax. Whereas if you add the child during the lifetime, they won't get that benefit.
This is Kelly Broaddus with Broaddus Properties Group, 928-606-6749. We look forward to serving you. Thank you so much.